There are often times where I have clients in that situation say, well, let's start really high with a cash offer. Let's go 3 times the price of this vehicle and then we'll meet in the middle. I'm sure that's how it'll work out. That's not correct. There is a rhyme and reason when we make a recommendation on how to negotiate and what to start with in our numbers. It's based on the type of issue you have, whether or not your issues took place within the lemon law period or outside, and also the mileage. So there are several factors that weigh into when we make a recommendation on where to start negotiations.
Welcome to Lemon Law Unpeeled, the Lemon Law podcast. I'm Emma.
And I'm Courtney.
And I'm Stephen.
And today we're going to talk about negotiating lemon law settlements like a pro. We're going to discuss the benefits of having an attorney by your side as opposed to trying to do it on your own, because there's so many variables that come into play when you're having these talks with the vehicle manufacturer. And as we've explained before, there's never any, automatics when it comes to lemon law. I think the hardest part about being a consumer and trying to negotiate these settlements is knowing what your case is worth. Right? Everybody just wants the buyback, but even if they get that, they don't know how the calculation works. They don't know if they're getting the right amount of money back. So it's actually way more complicated, I think, when it comes down to it than it seems to be on its face. Because we've had clients call in before and say, Chrysler denied my buyback. I don't understand how they could possibly do that, and things, of that nature, which is, at certain points where we have to get involved or look at the case and see kind of what the issues are. If a client does, get a buyback on their own or a favorable result, I do think some of it just sort of comes down to luck, right? And getting the right claims representative that was looking at the case, because most of our clients, right, come to us after they've already tried with customer care and haven't really gotten anywhere.
Yeah, absolutely. I think a lot of times when clients are trying to do it on their own too, they don't necessarily realize that an initial offer may be negotiable. We always go back and try to get offers raised. And 9 times out of 10, these offers are negotiable, not so much for the buybacks, but for the cash and keep offers. Whereas a lot of times clients will say, this is the offer I got. And I'll ask, well, did you go back to them? Did you try to negotiate it? And they say, no, I didn't realize that was something I could do. Or also somewhat related, sometimes the only cash and keep offer that a client will receive on their own is a few months of payments back. So say the vehicle was out of service 2 or 3 months, the manufacturer's rep will offer them 2 to 3 months of payments. Whereas we can normally get a lot more than that under the law. And a lot of times clients just aren't informed to realize, under the law, the measure of damages isn't just the amount of time my vehicle is out of service and those lease or those finance payments, but it's actually much more than that. It's actually the depreciation and value of this vehicle. So just being informed on the law allows us to a lot of times get far more money than you may be able to get on your own.
Another thing that clients really need to take into considerations, it's not just simply about the issues that are taking place, is when are these issues taking place? Are they taking place when you have under 5,000 miles, or are they taking place at 60,000 miles? A lot of these additional factors do weigh in when it comes into cash negotiations. There's a little more room to play with sometimes when you have a lower amount of miles, because this is taking place early in the process of your vehicle ownership. In contrast to when you have a vehicle for several years with a lot of miles on it, it's going to weaken the ability to argue that you have not been able to use the case. You need to consider your situation, know that it's not going to be always a grand slam, and know that sometimes it is best to seek out legal counsel so that way you can get a better understanding of what you're going to be dealing with if you go into negotiations.
Right, because I've had it where clients, they'll call in and say, I don't know why they're giving me the runaround. This is a slam dunk. It's clearly a safety issue. But like you said, okay, maybe it is a safety issue, but if we take, Maine lemon law, for example, you only had one visit within the 3-year 18,000 miles. Everything else happened after that. So technically you don't qualify, because the manufacturer will evaluate these buybacks based on your state's lemon law. So they're not just looking at, what you've experienced. They're also going to be looking at, what are we responsible for? What is our exposure in litigation? Because that's what a lot of clients say, right? Oh, they're going to spend so much money on attorney's fees in court that there's no reason why they can't give me $10,000 for this. They're going to spend $30,000 if they have to go to trial. And it doesn't really work like that. That's not always how they look at it, right? They're looking at it in terms of what their exposure is. Are they actually on the hook for lemon law? Will they actually have to buy your vehicle back if they go to court? And what are the chances of that when they're determining whether or not they're going to offer that to you? And oftentimes they just try to placate you, right? Oh, we'll give you 1 month payment, we'll give you an extended warranty, or things like that that really don't do much for you and ultimately are just kind of used to get you to go away when it comes to these cases. Or sometimes you're just premature in asking them for the buyback, right? You don't have enough visits and you're going at it too soon, and you need to spend more time accumulating your visits before you can press forward. But consumers don't really realize this. These are all things that we usually have to explain to them when explaining why we don't have a buyback or why we only have a cash offer or why, it was denied.
Yeah, and sometimes you really need to take the emotion out of it too and look at it just from an objective standpoint. For a client, it's hard to do that. They're looking at it subjectively. They're the ones who are going through this. I have a client right now who her vehicle's unrepaired. She's a New York client, but she doesn't meet the requirements of the New York Lemon Law. The vehicle was only out of service 2 times for a total of 3 days before 18,000 miles. In New York, you need 4 times or 30 days. And there's just nothing that we can do to change that. And she keeps saying, well, it's not fair. And if I could just argue my case, I'm sure anyone would agree with me. I'm sure anyone would feel for me. And unfortunately, that's just not going to cut it. Even if you're in front of a jury, if you don't meet the threshold of a law, it doesn't matter how bad those jury members may feel for you, they can't award for you under a law that you don't meet the requirements of. In fact, it would probably be booted on summary judgment. You wouldn't even be able to argue that law or plead that law. So it's just, you sometimes just have to backpedal and look at it objectively and say, what is my best case scenario here? And maybe it's just the lesser of 2 evils, but you need to not shoot yourself in the foot and make the best business decision possible.
And there are often times where I have clients in that situation say, well, let's start really high with a cash offer. Let's go 3 times the price of this vehicle, and then we'll meet in the middle. I'm sure that's how it'll work out. That's not correct. There is a rhyme and reason when we make a recommendation on how to negotiate and what to start with in our numbers. It's based on the type of issue you have, whether or not your issues took place within the lemon law period or outside, and also the mileage. So there are several factors that weigh into when we make a recommendation on where to start negotiations, because it's not like in the movies. It's not like in TV. I'm sorry. You don't start high and they start really low and you meet perfectly in the middle at the right number. There is a little room for negotiation and to push back and forth to weigh out, but both our side and the manufacturers do have an approximate idea of what your car's value is, what the depreciation value is because of the issues you're having. And so these are all weighed in when we say, well, we would recommend this amount. And you might be like, well, why? What's the deal? You don't want to start so high that you're just saying, well, forget about it, because sometimes the manufacturer will be like, well, all right, then go ahead and proceed to court if you wish. That happens sometimes, not all the time. Most of the time, everyone wants to try to see if we can reach a resolution. But if you don't start on a realistic foot, they're not going to start on a realistic foot, and it's just going to take longer and longer to try to reach a resolution.
I actually say those exact words to clients all the time. So many times people will say, well, why don't we start with $20,000 or let's start with $30,000? They're just going to lowball us anyway. And I use almost word for word what Steve just said, that you don't want to start unreasonably high because then they are going to start unreasonably low. Be reasonable with them and they will be reasonable in return. And they're eventually going to come to a maximum number. And we're always going to get that maximum number out of them. No matter if we start a little bit higher or a lot higher, we're going to get that maximum. There's only so high that they're going to go, just like there's only so low that we're going to be willing to go.
I was just going to say, I have this client. It was frustrating, but in retrospect now, probably like one of the funnier phone calls I've ever had, where it was a New York case, Mitsubishi, who is actually pretty good to deal with. We usually have to go to litigation for them, but it's usually, a pretty early resolution. And I had recommended, like 6,000 to 8,000, somewhere in that ballpark. It was an older-ish vehicle, but it had tons of miles on it. He had put something like 60,000 miles on over 2 years. So that automatically just kind of shoots your case in the foot because there's no impairment to your use. If the vehicle was that bad off, you wouldn't be able to drive it that far. And he told me I needed to be optimistic. I needed to think optimistically. And that if you don't do that, then of course it's going to go negatively. And he wanted me to start at a $30,000 settlement demand, which is pretty much the same that the car cost him. Obviously, we did, end up settling it. It took a much longer time than anticipated. Again, because we started so high, Mitsubishi was basically like, do we just go to court on this. Like, there's no way I'm going to be able to come close to that number. But eventually, as time wore on, we were able to get to a more realistic level. But it's the same sort of thing where they think that just by starting high, that means more money. And similarly, so a lot of people who have more expensive vehicles think, well, because my vehicle costs more, that automatically means more money too, which isn't accurate. So the reason why these cash settlements that we have are a bit lower than you would expect is because the way that our expert has to assess the diminution in value or the loss in value in your vehicle due to these issues is he has to look at current Kelley Blue Book values. The law says, hey, the diminution in value happened at the date and time of purchase. But since he doesn't have a crystal ball to go back in time and be able to tell you exactly what that was then and there, he uses current Kelley Blue Book values, and the difference between, we'll say, hey, this vehicle would be in excellent condition, but for these defects, it's only in fair condition. And he has to use the percent difference between those numbers to help guide his loss in value. It's not a determinative percentage, but it definitely has to be used to guide him, and his number can't be too far off of that percentage. So if you have any familiarity with KBB, you know that the difference between, let's say, excellent to fair is maybe a couple $1,000s, right? You'd be in the $26,000 to $24,000 range if it was an excellent, but since it's only in fair, you're in $22,000 to $23,000. So their hands are kind of tied in court in terms of being able to put these huge percentages on them. I would say like 15% is pretty much the average. But again, that doesn't go across the board, right? If we have a Land Rover that was $80,000 with a Bluetooth issue, and we have a Ford vehicle that was $35,000 with the same issue, just because they paid more money doesn't automatically mean that you're going to get a bigger recovery. There is a balancing act, and there are some scales there that we have to be aware of when we're making these resolutions and deciding, hey, this is actually a realistic figure if we were to go to court, and so it makes sense to settle for it now.
One thing I often see is people try to throw in for cash resolutions or negotiations. Well, hey, what about my pain and suffering? What about the inconvenience to me? What about my lost wages? Unfortunately, the law does not take in the human factor in this situation. It is based on solely your vehicle's performance, the issues your vehicle's having. It is looking at the vehicle, not the human factor. Clients often have a difficult time understanding that just because you had to take a day off of work, while it is unfortunate for you, that is not taken into consideration for a breach of warranty or a lemon law claim. So we have to set aside that human factor and look at the vehicle specifically so we can get you the best outcome possible in a realistic manner.
Yeah, we're often asked about lost wages or even inconvenience, aggravation, mental anguish having to deal with these issues. And unfortunately, that's just not stuff that's recoverable under these laws. It's not like we're going to court for a personal injury claim and we can throw all sorts of extraneous claims in there. It's very cut and dry what we can recover for. And unfortunately, it's just not all that much.
Yeah, and Steve's totally right about pain and suffering. I've gotten some emails, and I'm sure we all have, of clients kind of making up their own calculation for what their damages should be. They throw, their insurance costs in there. They throw in, the time spent at the dealership. They throw in pain and suffering. They just, I've had to go to the doctor. I have anxiety over this. All of that gets thrown in to make this calculation that unfortunately we can't support in court, because that's how we have to look at these cases, right? We're in this pre-litigation phase. We're discussing a settlement with the manufacturer, and the only time that settlement would make sense to accept is if we didn't believe we could do better in court, or if we could maybe do a little bit better, is it worth the year plus that we might spend in litigation to get those additional monies? For example, I had a client recently where we had an offer which was, in the ballpark of what I recommended, albeit the lower end. But I was like, listen, maybe we could go to court. Maybe we could get $1,000 to $1,500 more for you. But between depositions, inspections, time that you have to continue to own this vehicle, and the natural depreciation that goes through that, or natural depreciation that goes with that, your $1,000, $1,500 isn't going to mean anything in the end. It's just going to compensate you for that additional time. So you really have to balance the scales because, as Courtney pointed out previously, court is not like you see, like Steve said, on TV. You're not going to be sitting there, because the plaintiff themselves also only get to answer questions that are asked of them. They don't get to stand up and do some like soliloquy in front of the jury where they go on and on about how much this has impacted their life. They don't get to give a statement like that. Instead, they're asked questions on the witness stand that we prepare, and then the defendant has the right to cross-examine them when we are presenting these cases. So it's, not what we usually hear where I don't see how any judge could disagree with me. It's just unfortunate that that's just not how it works. That's not how the law actually plays out, along with having to have a law under which you can recover, right? I tell clients all the time, oh, the judge may 100% agree with you, but they then have to look to the law and say, what am I allowed to award? What am I allowed to give this person? Because if they give you something outside of that, that's appealable, right? Because that could be seen as an error of law. There's nothing in the law that allows you to award those types of damages. And then you're back up on appeal and possibly kicked back down just to start all over again and have to go through the whole trial again. So like we said, you kind of have to have a more realistic view when it comes to these cases and what you can expect from them, which again is why it's so important to have an attorney that's there to guide you, because nothing under Lemon Law is automatic. I'm sure we hear that all the time. I have my 4 visits, or I have my 30 days out of service. I was within the timeline. Why aren't they just buying it back? Well, there's a lot of factors that come into play that make it not so cut and dry.
I have those same conversations all the time where a client will say, well, I read the law and this is a lemon. There's no bones about it. This is a lemon. And they don't realize, well, there's this nuance here that says that the issue has to continue to exist, or there's this caveat there. And Emma, along the lines of what you were saying also about how going to trial is not always necessarily what a client thinks it will be. I've actually had multiple times where we've been walking out of an arbitration room and a client has expressed to me how frustrating it was and how they actually feel more frustrated now than they did when we walked in. And they had gone in thinking they were going to feel so vindicated and they were going to be able to tell their story and people were going to agree with them. And that's just not how it is. First of all, arbitrations and even the trials, it's a close room. There's no media there. There's no extra people there that are going to feel for you or be backing you up. And like you said, Emma, you're asked questions and you answer those questions, and that's it. There are so many times where a defense attorney might be giving their closing argument, and I can see my client there itching and sometimes, trying to stand up and say something. It's like, no, sit down. You are not allowed to talk right now. And it's extremely frustrating to them.
Another experience during the litigation process that can be very challenging to deal with is depositions. I've had deposition where my client was being asked for 3 hours, questions, just going on. And the questions were improper, but it was a long process where the client kept getting frustrated, kept getting aggressive, kept changing words. It was a very difficult process because the clients just wanted to say what he wants to say. But what you got to remember is they're asking the question, you need to answer the question. There is a process and there are rules to how a deposition should go. It's not going to be a dramatic speech made as you see on TV where they just break out and all of a sudden the opposing side's like, you're right, you got us. That's not how it works. It's actually a very intrusive process, unfortunately, where they ask you numerous questions where you might not know why they're asking, but they have a reason why they're asking, even if it may be about speeding tickets from 2 years ago. There are a lot of weird questions that come out in depositions. So with that being said, it's always good to try to go through negotiations and not just say, I want to file a court. I don't even want to negotiate. Why are we even going to waste our time with negotiations? Because it can take between 6 months to a year. Even during the pandemic, I had a case that was 2 weeks from trial that got adjourned for another year. It was a 2-year process before we were able to reach a resolution before court. Now, that was during the peak of the pandemic, but things can happen. You don't know what could happen in a courtroom. The judge may get sick. Judge may say, well, I'm going to adjourn this because my docket's too heavy. That does happen sometimes. Before you go that direction is a good way to see what realistically you may be able to do for your case without having to go through the burden of 6 months to a year of litigation.
I just got a trial court in New York for 2027. It is currently February 13th, 2025. And it's not even New York City. It's Clinton County. It is up near Vermont. It is 6 hours away from Philadelphia. And so, like you said, you just don't know. Who would have thought that a docket in a little county that far away would be that heavy? You just don't know. And then you've got to hold on to the car the whole time. You're racking up miles. And that's something I have a current main case going right now. And the conversation we keep having is she's saying, I just don't understand. To me, this is a clear buyback case, which she does have a substantial issue. It was out of service for 15 or more business days within the time period. It is still ongoing. but she's put over 20,000 miles on the vehicle in less than 2 years. So as I explained, I was like, listen, just like we are going to fight for your case, the other side is going to fight to diminish your case as much as possible. I think that clients kind of forget that there's an opposing side, right? And that there's another attorney there who isn't going to be tripping up over the words, being like, oh, like you said, oh, this is amazing. That's it. We concede. They're going to be sitting there pouring over your repair orders, pouring over the amount of miles you've put on it, and taking out every little nugget that they can to minimize your problem, right? Oh, you had a no-start problem? Well, you've put over 20,000 miles on your vehicle in this time period. The average consumer only would put, 15. So how can you say that this substantially impairs your vehicle when you've driven it so much? And, it's a fair argument. And the persons listening to the case may agree with that. I mean, even I can see that point, and I, don't necessarily agree with it either, but it makes sense. And even when our clients do get the buyback, right? So let's say, take the flip side of that. They have, in your face, obvious lemon law case, Ford or whomever agrees to buy it back. We collectively, all three of us have been doing lemon law, for well over 15 years. We are still arguing with manufacturers over the correct lemon law calculations for these cases. It's not cut and dry. It's not that clean where it's that obvious. We have it now where we're arguing over mileage. We're arguing over whether taxes come back. We're arguing whether gap insurance comes back. We're, sending screenshots back and forth of what the law says and what this says. And it's not as clean as you would think it would be than just, hey, okay, you got your buyback, here you go. Because every state's lemon law is different and they all let you recover different things. And that's what can make it really difficult as well to do this without an attorney. Because if they want to, they can send you a bare bones offer that you just kind of have to roll with because you think that that's all that you're entitled to.
And also, we even have one going on just recently where the dealership, different notations on dealership agreements, they're not all the exact same contract for every single dealership. And the way they mark down numbers can be confusing if you're not used to looking at these. You might be like, well, did I pay this much or did I pay this much? I recall doing this, but it's actually saying this. There's a lot of breakdown in the numbers that you don't really realize are taking place when you purchase or lease a vehicle.
Yeah. You and I this morning were trying to figure out this repurchase offer that we got that neither of us could get the math to add up. It turns out, I do believe that they did the math wrong because it's a lease where, the down payment includes that first payment. So they had the first payment included in the down payment, and then they had it included again in the monthly payments that were paid. So technically it is incorrect. But again, this is a manufacturer that does these all the time. But to make a slip up like that when they have to go through auditing is wild. But they forget that the other side's human too, right? There are just people on the other side that are putting all these together and sorting all of this out, which again is why we kind of circle back to having an experienced lemon law attorney really helps. We know the law, we know what you're entitled to, but even for us, it can be complicated, right? Everybody knows I love a good spreadsheet when it comes to these repurchases, because that's really the best way to be able to track all this is to have a spreadsheet that breaks down every piece of the purchase agreement. And I'm sorry, but I don't think your, average consumer is going to really be able to do that on their own without, some guidance.
Yeah. And Emma, even going back to what you were saying about not necessarily realizing that there's going to be a defense attorney on the other side when you're sitting in a courtroom who's going to be arguing everything against you, sometimes it can even get personal. And I've had clients get upset. You used the example of a no start and someone was still putting a lot of miles on the vehicle. And to a judge, they're going to hear, all right, yeah, you were still driving it. And it was a similar case where I had the defense attorney actually point out to my client and say, I noticed that you have car seats in the vehicle. Is that correct? And they said, yeah. So you drive your children in that car? Yes, I do. Well, why would you put your child in a car that you're telling us is so dangerous? And clients can get really upset and they can get really defensive. And that's when you really just have to take a step back, and it helps to have an attorney there, know what objections to make and what you are allowed to insinuate and not.
Right. It's easy to have an argument in your head, right? It's easy to have that argument without somebody else on the other side pointing out all the negatives, or even going over with your spouse or a friend or family member. They're just going to agree with you. They're not going to sit there and point out the counter to it. So yeah, it's very easy to be like, I've got an open and shut case. But nothing in the law world, with the exception of like strict liability cases, is open and shut, right? There's always room for interpretation. There's always that chance that you can get a judge or jury that's not going to agree with the plaintiff. And that's why they take those chances. And that's why they're not offering buybacks on every single car that comes through, because they know that that chance is there and their exposure is not going to be that great, potentially, right? Depending on what the issue is or the case is. And that's really going to drive how they determine what they're going to offer and what outcome they expect. And so with that, I think what the main takeaway is here is that it's really important to have an attorney there to guide you as you're going through this process, because it is much more complicated than it seems on its face. There wouldn't be a whole area of law dedicated to it if it was that simple. And it's really important to have an experienced lemon law attorney on your side to help walk you through it, to know what you are and are not entitled to. Again, as we always inform you, your Attorney General's website will always have really important information in there as well, along with the BBB. But again, you can call our intake line at 833-4CAR-LAW. We're always here for a free consultation and to help you as you are navigating the lemon law waters. And with that, we want to thank you for listening today, and we'll see you next time. Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robison Lemon Law Group. Individual results also may vary as outcomes are determined on a case-by-case basis.